Thanks, Stephen. Well, it's delightful and a pleasure to be here. I'd like to thank, in particular, well, I have to thank our sponsors, but I'd also like to thank my hosts, in particular Zoe and Stephen and Jason, who've looked after me extremely well while I'm here. All Canadians are extremely nice in my experience, but you're exceptionally lucky to have these three people at this law school. So not are they the three of the nicest people I've met, I know, the three of the very best scholars I know in the world, and so you're just dead lucky to have the three of them. But I was told that I'm, one of my hobbies is mocking Nares, so let's have a bit of mockery of Nares. So I'm one of the very few people, in fact I'm prepared to bet I'm the only person in this room who's played a game of football with Jason Nares, if you can imagine that. And so Jason was in goal, and it was during a friend of ours stag do in England where Jason was delegated to playing goal. And the team we were on was a very serious team. We played together in Oxford, and we don't like losing. And Jason was playing in goal as a guest, as it were. And we were winning 2-1. And a couple of members of our team were blaming Jason for letting in one of the goals, wholly unfairly, in my opinion. And it came to the very last minute, the very, very last minute of the game, where the opposition striker was clean through on goal. And the only thing standing between us and our victory being snatched away from us was Jason in goal. And I say openly to you now, there was not a lot of optimism on our side. At that moment, and their very best player was the striker, and he struck it into the top corner. It was a beautiful shot, and if you can envisage this, it's just a vision of beauty, really. Jason leapt like a young gazelle and palmed with his fingers the ball away. I swear to you, I've never cheered so much in a football game in my life as when Jason saved that goal. Okay, so what am I really here to talk about rather than the mockery of Nares? Right, so what I'm really here to talk about, what I'm billed to talk about, is causation and contribution and the difference. So when I was a law student 20 years ago, my law tutor used to write the same thing on the bottom of every essay I ever produced. Every essay I ever produced always had the same thing on the bottom, which was room to pin down the issues more precisely, but which he meant you're just running together too many different arguments, separate them out. And he put that on the bottom of everybody's essay every week, and so it was actually quite an easy job that he had there, marking those essays. And it got to the stage where we actually bought him a stamp where we could just stamp that at the bottom of each of our essays, room to separate out the issues more precisely. But it's actually really good advice if you're a law student. One of the key lessons you've got to learn is to separate out the issues, and that's really important in relation to causation, so that causation isn't simply a sort of blob where all the cases are all concerned with the same thing. There are actually many of them concerning quite different issues. So what I'm going to first start off is try to explain what I'm not going to be talking about, okay? So what am I not going to be talking about? Right, first thing I am not going to be talking about is I'm not going to be talking about issues of proof, yeah, and the difficulties which issues of proof but the difficult issues of proof which arise where we have multiple potential wrongdoers. So a classic example of this, which I'm sure if any of you studied any tort law at all will know, is the example of multiple hunters who fire into woods, and there's a victim in the middle who has a single bullet hole through their heads, and it cannot be shown from whose gun the bullet came. So you're all firing into the woods, I'm in the middle of the woods, and there's a single bullet hole. We can't tell whose gun it came from. And so I sue you, and I can't show on the balance of probabilities you hit me, and so on and so forth. What do we do in that situation? Well, I'm not going to talk about that issue. The leading case, the case concerning those facts is Cook and Lewis. The Supreme Court of Canada has recently ruled on said some obiter dicta statements in relation to this in Clemens and Clements. But those sorts of evidential holes, those evidential problems where we know some wrongdoer hit me, but we can't identify which one, I'm not going to be talking about. The second issue I'm not going to be talking about are what we might call issues which are labelled legal causation, or remoteness, or proximity, or sometimes, if we were in America, which thank the Lord we're not, scope of liability. So I'm not going to talk about any of those things. Those issues are really concerned with selection amongst a number of possible causes and identifying which one is responsible. So we've already identified that each what the causes, as a matter of fact, were, and then we select amongst them to say, well, that's the legal cause, or that cause there is too remote to be responsible. So an example of that phenomenon might be, say, my life. Yeah? So 44 years ago, my father looked at my mother with a twinkle in his eye on a cold winter's evening. And as a result, I am stood here today lecturing to you. But we wouldn't say that he was responsible for this lecture, thankfully. Although his action, when he looked at my mother on that cold winter's evening, did, in a but-for sense, cause me to be here, we wouldn't say, well, he's responsible for the lecture. And that question of selection amongst factual causes I'm not going to be talking about. So that's two issues I'm not going to discuss. Firstly, evidential gaps. Secondly, questions of legal causation or remoteness. Those aren't going to be discussed. What am I going to be discussing then? Well, I'm going to be discussing what causation and contribution mean. Now, since the 1960s, the dominant approach in legal scholarship has been the approach adopted by Hart and Honoré. So what Hart and Honoré did in their magisterial book on causation was they gathered together millions and millions of cases and looked at the usage of the word cause in those cases and tried using the usage of the courts to discern what causation meant. So they're using the law, the case law, to determine what causation meant. Now that is, I think, a very dangerous thing to do. Indeed, I think it's an error. And the reason it's an error is twofold. First of all, when you look at a case, there may be many reasons why a claim succeeds or fails, which has nothing to do with causation, strictly speaking. So if some of you have done tort law, some of you will have heard of the case of Poolsgraf against Long Island Railroad Company. Now, if those of you who know that case will know that there's a debate to be had about whether or not that case is really about the duty of care or it's really about causation. Now, as it happens, I think it's to do with duty of care. But the problem for us when discussing causation is, as lawyers, there are different ways of explaining results, and so trying to read back from the cases into the law of into the meaning of causation is dangerous, because there may be other reasons why a claim is succeeding or failing. The second reason it's problematic is what we as lawyers are really concerned with, what we're really interested in, isn't causation at all. That's not what we're interested in. What we're really interested in is responsibility. Who is responsible for an outcome? That's what we're interested in. And we're interested in that in the criminal law, in contract law, tort law, law of unjust enrichment, all across the law. We're actually interested in responsibility. And the law may determine that somebody either is responsible or should be treated as responsible, even though they've caused nothing. Yeah. So an example of that, I'll give you a silly example of that. This is an example from Voltaire. So in the Napoleonic Wars, the British lost the island of Minorca to the French. So we lost the island of Minorca to Napoleon. And so the question is, what do we do about that? And, well, the admiral in charge of that area of the Mediterranean was a chap called Admiral Byng. And so what the British did was they executed him. They hanged him from the neck. Yeah? Now, Admiral Byng was in no possible moral sense responsible for the loss of Minorca. He didn't cause this. There's nothing he could have done. But the reason we held him responsible was pour encourager les autres, to make sure that the other admirals in the future met the mark. So you just kill a few, and that way the future admirals will be, a bit more careful in conducting their business. We as academics do the same thing with students. We always fail a few just to, raise the standard of the rest. I mean, these guys are notorious. Now, you may think that's unfair and the law shouldn't do that, but for good or bad reasons, the law does treat people as responsible for things, even though they've not caused them. So it's dangerous to read read from the law to the meaning of causation, because the law may be treating people as responsible who haven't actually caused anything. So, what I'm going to try and do today, instead of doing the game that Hart and Honoré play, is to try and talk to you about what causation and contribution mean outside of the law. So I'm trying to stand outside the law and talk to you about what causation and contribution mean, and then, once we've got some conclusions, take that back into the law and see how that plays out in legal examples. Now, it may be that you don't believe me. You might think, well, he's just going to cheat, isn't he? Because it says on his CV, Professor of Law. So what he's going to do is he's going to lie to you about what causation means and then get to the answers he prefers. I can't tell you that that isn't going to happen. So, 3 tasks I'm going to attempt. So in what follows, I'm going to attempt 3 things. First, I'm going to try and discuss what we mean when we say that something was necessary to cause something else. What does that mean? So we're going to talk about necessity, number 1. I'm going to talk about what it means when we say something was sufficient to cause something else. So I'm going to look at sufficiency. Okay? That's my first task, looking at necessity and sufficiency. The second thing I'm going to talk about is I'm going to try and make good the proposition that causation and contribution are different things. Yeah, so I'm going to try and separate out causation from contribution, and I'm going to try and explain what I think causation actually means. The third thing I'm going to try and do is I'm going to try and separate out causation, contribution and responsibility, and argue that the law sometimes treats people as responsible for outcomes despite the fact that they've only contributed to them, that they haven't caused them. Yeah? And that's fine. There's nothing morally objectionable about that necessarily. But it doesn't tell us anything about causation necessarily. It tells us something about the different idea of contribution. Okay, so let's try and do this. Right, so the next little bit is quite tricky, so you have to wrap cold towels around your heads, metaphorically, to listen to this next bit. Necessity. What do we mean when we say that something is necessary to cause something else? So say I shoot a gun in the woods and I fire the gun in the direction of a rabbit, and the bullet hits the rabbit in the head and the rabbit is dead. When any of us are asked what killed the rabbit, we would all say it was my shot which killed the rabbit. That was the cause of the rabbit's death. But that's slightly more difficult than you might think as a conclusion, because everything in the world is necessary for the existence of the universe as it is. So if there's a tree 100 miles away from the rabbit, if we took the tree away, the universe is changed. So why are we saying it's the shot which causes the rabbit's death and not the tree? Now, why is the tree not causing the rabbit's death? Because the presence or non-existence of the tree alters the universe. Well, the answer to that is it depends upon what you mean by dead rabbit. Yeah? It depends what you mean by dead rabbit. It depends upon your definition of dead rabbit. And there's no logical way of defining that. It depends upon what you mean as a matter of words by dead rabbit. Yeah? And when we describe the dead rabbit, in our description of dead rabbit, we don't include the tree. So we don't think the tree is a cause of the death of the rabbit. But that's only because we have a conception of what a dead rabbit is. It depends upon your definition. Now, frequently, there's what we might call a temporal ambiguity in relation to what we mean by causation. So say I have a bucket of ice in this room, and the room's in ambient temperature. So we're above freezing in this room, unlike the rest of Canada. So what I do is I put the bucket on a hot stove, and the ice melts. Yeah? And then we ask the question, well, did the stove cause the ice to melt? Did the stove cause the ice to melt? And we ask that question the next day. So the following day we ask the question, did the stove cause the ice to melt? And actually there are 2 possible answers to that question, not one. It depends upon what you mean. So you could say, well, the stove didn't cause the ice to melt, because today, the next day, you would have a bucket of water anyway, regardless of putting the ice on the stove. It would have melted anyway because the room's of ambient temperature. So the same thing, the same state of affairs would have occurred but for the stove. So you might say the stove didn't cause the ice to melt because it would have happened anyway. Yeah, that might be one answer. Another answer is to say no. We don't judge the question of whether or not the stove caused the ice to melt from the perspective of the next day. We look to the time at which the ice is melting and we judge it at that moment. What is it at that moment which is operating upon the ice? To which the answer is the stove. So which you might say, well, the stove does cause the ice to melt. So in that situation, there's a temporal ambiguity. When we talk about the melted ice, what do we mean? Do we mean the end state of affairs of the ice being melted? Or do we mean at the time the ice was melting, what was operating on the ice? Yeah. Now you might say, well, this is just trivial. But actually, as a matter of law, as we'll come to see, as a matter of law, sometimes the law means the time of trial, the next day, the subsequent position, the end state of affairs, and sometimes the law doesn't mean that. What it actually means is what was operating at the moment at which this event occurred. Yeah. So the law itself sometimes is adopting one perspective and not the other. Okay, that's enough on that. Sufficiency. Sufficiency. What do we mean when we say that something was sufficient to cause something else? So what does sufficiency mean? Well, here's just a proposition of logic. Nothing on its own is sufficient to cause anything other than itself. In the physical universe in which you and me live, nothing is sufficient to cause anything else on its own. The only possible exception to that is if you're a believer in God. Right? So if you believe in God, you might think that God can be an uncaused cause. That God, as it were, on its own, can change the universe without any other interaction with anything else. But that's the only exceptional case, right? So then you've got to believe, you've got to make the leap of faith to believe that. In the physical universe as we perceive it, nothing on its own is sufficient to cause anything else other than itself. Yeah? So, take some examples. Say we have a pear on a shelf. We have that pear on the shelf, and over time, that pear will rot. Yeah, will rot. Well, is the pear sufficient on its own to cause the rotting state of affairs, the smell and the stink? The answer to that is no. No, because the pear needs to interact with other things in the universe in order to create the rotting smell. It needs moisture. It needs the fact that particles combine with other particles in order to rot. You know? It needs bacteria in the air. You know? So that it has to be pear plus moisture plus bacteria plus time, which causes the rot. The pear itself, on its own, can't cause anything other than itself. So think of it like a rock in the universe. You just have a rock sat there in the middle of the universe, out in on its own. Rock plus nothing equals rock. Nothing can be anything other than itself. So nothing on its own is sufficient to cause anything else. So once we've accepted that, what do we mean when we say A was sufficient to cause B? What do we mean by that? Well, what we must mean is that it was sufficient in combination with one or more other things. That when we say A is sufficient to cause something else, it must be sufficient in combination with something else. It's the only possible thing it could mean, because nothing on its own is sufficient to cause anything else. And that idea of sufficiency is the idea that Hart and Honoré adopted in their definition of what causation meant. And it was that idea which was then latched onto by a man called Richard Wright, and he made a career out of defining this definition in terms of something called the NES test, which means necessary element of a sufficient set. You don't need to worry about that. All they really mean is sufficiency. And so what they're talking about is saying that causation is about sufficiency, not necessity, is their idea. Okay. I'm not accepting that today. I'll make that clear. Now, next thing we're doing is we're going to distinguish causation from contribution. What's the difference between causation and contribution? And I'll give you an example to try and illustrate that. Now, I live in Oxford. I live in East Oxford, which is essentially the inner city ghetto of Oxford. And where I live, when we have elections, the Labour Party candidate always wins by a mile. Always trumps the next candidate, because we have first past the post elections, and the Labour candidate always wins. So let's take an example. Say we have our Labour candidate, so we'll have Zoe as a Labour candidate. There you are, there's our candidate. And I am one of the people who votes for her. So I cast a vote. I vote for Snell. Very foolish, but I do it anyway. So I vote for her. I cast my vote. And in total, she receives 7,500 votes. So Sunel gets 7,500 votes in her favour. And the nearest opponent, the rather dubious opponent. So what we have you stand for? You can stand for the UK Independence Party, yeah? Our dubious opponent gets 5,000 votes. So 7,500 for the winner, 5,000 for the second place. And then we have Nares with 2. So the question then is, was my vote sufficient to cause Zoe's election? Yeah. Well, we actually might be prepared to say, in the light of what I just said about what sufficiency means, that I am sufficient to cause Zoe's election, that my vote was sufficient. And the reason we might say that is because we've already noted that nothing on its own is sufficient to cause anything else. That what we mean by sufficient to cause is sufficient in combination with other things. And my vote, in combination with 4,999 others, no, sorry, I've got my numbers wrong, 7,499 others, caused her election. It was the bulk of votes which caused the election. So you might say that my vote was sufficient, although it wasn't necessary, because take away my vote and she still gets elected. Now, I would suggest that indicates that when we look at that example, very few of us would say that my vote, my single vote, caused Zoe's election. I don't think it did. I don't think my vote caused Zoe's election on its own. Now, which means, I think, that when we talk about causation, we don't mean sufficiency, contrary to what Hart and Honoré claim. That if we did mean sufficiency, then you would say that my vote alone caused Zoe's election, and I don't think it did. What did cause Zoe's election then? Well, we have a number of different answers to that. What we could say is that 5,001 votes caused Zoe's election. Why does 5,001 votes cause her election? Well, if she's got 5,001, she beats the next candidate. So just as long as she's got 5,001, she wins. So we might say that that's what causes her election, because she needs 5,001 votes to win. And that's a necessary cause, so that 5,001 is the correct number to select. Yeah? But notice, when I say 5,001, I'm not actually talking about any particular votes. Yeah? We're talking about 5,001 votes in the abstract. What she needs is a group of 5,001. Not any particular votes are we referring to, but the abstract number of 5,001. She needs that. So you might say that's the cause. An alternative answer, is to say that it wasn't 5,001 votes which caused her to be elected, but 2,500. And the reason we might choose 2,500 is, if we take away 2,500 votes from her, then she no longer has a majority. So you take away the 2,500, she doesn't win anymore. But when we say 2,500, what we actually mean is real-world 2,500. So if we remove any real-world group of 2,500 votes from her, all of us, say we're 2,500 people, we remove our votes, she loses. So we're not, when we say 2,500, referring to an abstract number, we're talking about real-world votes. We remove those 2,500 votes, then she is not elected. And we might say that's the cause. Yeah? But each time, I think we're really talking about necessity. Yeah? We're really focusing on necessity. We're asking, what was it that was necessary to cause her to be elected? Yeah? We're not talking about sufficiency. Well, does that mean What does that say about my vote? Does that mean that my vote had no influence on her election at all? Well, I want to suggest the answer is no, but that my vote contributed to her election. My single vote didn't cause her election, but it contributed to her election. Indeed, every vote cast in her favour contributed to her election. And that is the difference between causation and contribution. To contribute to something, it's enough for your contribution to be sufficient in combination with a number of things, even though it itself is not necessary. So my vote is not necessary for her to win, but it did contribute, because when we add it along with a number of other things, then it would be a necessary element of a set, if we like that language. Now, a quite separate question then becomes, am I responsible for Zoe's election? So we say I've contributed, I've not caused it, but am I responsible? And as I noted at the beginning, that's what lawyers are interested in. That's what we're interested in. We're interested in responsibility, not causation and contribution directly, but actually responsibility. Yeah? And I think that question is capable of being given different answers. So we might say, well, I'm not solely responsible. Now, clearly I'm not solely responsible. There are all these other people who voted for her. And we all were reckless and foolish, but we all voted for her. So we might say that I'm not solely responsible for her election. But if you say I am not responsible, if you say the person who casts a single vote is not responsible, that means that we have to say the same thing in relation to everybody who cast a vote in her favour. So if you voted for her, you're not responsible, and you, 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 and you. So we get to the answer, if we say that I'm not responsible, that everybody's not responsible individually, that no individual is responsible for Zoe's election. So we end up with the answer, nobody's responsible. I want to suggest that that's the wrong answer. I want to suggest that where the only thing which is causing this outcome is human agency, our decisions to vote for her, that each of us is individually responsible, even though we only contributed, so that we can be responsible for something, even though we didn't cause it, so that you can be responsible by contributing to something, even though you don't actually cause it. And remember that the law is interested in responsibility, not causation and contribution directly. Okay. Next tricky bit. This bit's really tricky. Okay, right, so draw a line under that. The next bit is about preemption. Preemption. Now this is hard. Now, I'm not sure I understand this, but we'll have a go. Preemption. There are two of us hunting this rabbit, me and Nares. Yeah? So both of us are after the rabbit. Yeah? And I see it first, a moment ahead of Nares, and I shoot. And he sees it a fraction of a second later and shoots. And so what happens is, my bullet hits the head of the rabbit a momentary fraction of the second earlier. And the rabbit is stopped in its tracks, and as a result, Nair's bullet never hits the rabbit. If my bullet had never been there, the rabbit would have taken another step, and the bullet from Nair's gun would have killed it. Yeah. So, does my shot kill the rabbit? Does my shot kill the rabbit? Well, what my shot did was it preempted Nair's shots killing the rabbit. So if we ask this question from the next day, and we look at this state of affairs, and we say, would the state of affairs of a dead rabbit have happened regardless of my shot? We would have said it would have happened anyway. The rabbit would just be just as dead if I had not fired my gun. So you might counterintuitively answer that my shot didn't kill the rabbit because it would have been dead anyway. Now I think that's the wrong answer. I think that's the wrong answer. Now, how do we escape that answer that my shot didn't kill the rabbit? Well, one answer might be to say, well, my shot made a momentary difference in time. So that tiny fractional difference in time is enough for us to say that I killed the rabbit and not Jason. But I don't think that's really very adequate. You know, the idea that to kill a rabbit is to make some infinitesimally small difference in relation to its moment of death can't be quite right. So I think the answer is that my shot killed the rabbit because it was a necessary part of the set actually sufficient for the death of the rabbit. So in the world in which we live, we know that gunshots kill rabbits by hitting them in the head. And it was only my shot which hit the rabbit. So that it was only my shot which was actually underlined sufficient to kill the rabbit. Jason's shot would have been sufficient to kill the rabbit, but it never hit. And we know that bullets kill rabbits by hitting them. Yeah? So that only my shot killed the rabbit, not Jason's. Even though, judged from the subsequent perspective, the rabbit would have been dead anyway. So that you can cause something, even though the same event would have happened anyway, if your action was necessary for the set of conditions actually sufficient for the death of the rabbit. So the fact that my shot preempted the death of the rabbit by Jason's shot isn't enough for us to say that I did not cause the rabbit's death. So that's preemption. Preemption cases are fiendish, they're really difficult. I hate preemption. I think that's the answer. Right, next issue. Another problematic issue, which those of you who studied tort should be familiar with, is the problem of overdetermination. Overdetermination. So this case is a case where both Jason and I shoot at the rabbit at the same moment in time. And at the same moment in time, both bullets hit the rabbit in the head. Yeah? So this sort of case needs to be distinguished from the sort of case where we started off at the beginning, where we both shoot into the woods and you can't tell which bullet hit. This time, both bullets have hit. Yeah? So there's no evidential gap. There's no piece of evidence or fact in the world we don't know about. We know all the facts that there are to know. We know that both of our shots hit the rabbit. And then the question is, against each of us individually, did we cause the rabbit's death? Did we, each of us, cause the rabbit's death individually? And you ask that about me as an individual, and you say, did Stevens' shot cause the rabbit to die? I think the answer is no. It didn't cause the rabbit to die, because it would have died anyway. That my shot is not necessary for the set of conditions which involves the death of the rabbit. It would have died anyway. Put in the language of but for, which you may be familiar with, but for my shot, the rabbit would have died anyway. You ask that about in relation to Jason, and we get to the same answer. Yeah? That his shot wasn't necessary for the death of the rabbit either, because the rabbit would be dead, so that Jason didn't cause the death of the rabbit. So we get to the answer, applying ordinary causal thought, that neither of us caused the death of the rabbit. Now, as lawyers, we suddenly get very upset about that answer. Oh, no, that can't be right. That's really upsetting. We don't like that answer. Why do we not like that? Well, on its face, if we say I didn't kill the rabbit and Jason didn't kill the rabbit, nobody killed the rabbit, and there's a dead rabbit. You say, oh no, this can't be right. But actually, that logical problem doesn't arise. So that actually isn't right. So that's a logical error. So the mere fact that I individually didn't kill the rabbit and Jason individually didn't kill the rabbit doesn't mean that we're driven to the conclusion that nobody killed the rabbit. No, that's not the answer. There are different answers we can give. So either what we can do is we can say what killed the rabbit was a shot. Yeah, or being shot. So that's the same answer as we saw in relation to the 5,001 votes. What we do is we talk about shots in the abstract. We abstract the answer and say it wasn't any shot individually, it was the abstract event of a shot which killed the rabbit. That's an answer. And logically that's fine. We don't need to, we can sleep comfy in our beds with that answer. An alternative answer is we combine Jason's shot and mine. So we say it was the shot of Stevens and it was the shot of Nayers which killed the rabbit. So we combine the two together. Yeah? And that's a cause as well, because if we take away both our shots, no dead rabbit. Yeah? So what we can do is we can aggregate the two events, my shot and his, and say they caused the death of the rabbit together. And as a matter of language and the meaning of causation, that's fine. So if what we were doing is we were talking to the philosophers, they'd say, well, that's the answer. What's the problem? Yeah? Well, the problem is we're lawyers, we're not philosophers. Right? The problem for us as lawyers is that claims are brought against individuals. Yeah? So the claim is brought against Nez as an individual, or against Stevens as an individual. And what we think is that we have to show causation vis-a-vis me. Yeah? And we can't do that. All we can do is show causation in relation to shots or a shot, but not anything causation in relation to anything I personally did or anything Jason personally did. Which seems to give you the horrible answer that it's a matter of law, neither of us individually caused the death of the rabbit. What I want to suggest is that problem is more apparent than real. That what we can say without doing violence to the meaning of words is that neither Jason nor I caused the death of the rabbit, but we both contributed to the death of the rabbit. Both Jason and I contributed to its death because both of us are sufficient to cause its death in combination with a number of other things. Those other things being the rabbit, gravity, the velocity of the bullet, and so on and so forth. That we can say without violence to language that each shot contributed to the rabbit's death. Now, I think I emphasised earlier that the law is actually concerned with responsibility and not causation and or contribution specifically. And is that a problem? I want to suggest it isn't. The law is perfectly capable of saying that both of us are individually responsible, even though both of us only contributed and didn't cause. Yeah? And that's the right answer. The right answer is not to do violence to our understanding of causation and start telling lies. Now, I don't like telling lies. It is a lie to say that I caused the death of the rabbit. I didn't. I just contributed to it. Just like I only contributed to Zoe's election. I didn't cause it. Okay, right, we're lawyers, so I'll give you some law examples now so you can breathe now, so you can answer all the theory. Thank God for that, right? So here's some actual case law or some examples to try and illustrate what I've just been saying. So first of all, we'll take the criminal law, so we'll do a bit of crime. So say I shoot you in the head. So I shoot this individual in the head. But we can prove beyond peradventure, beyond any doubt, that the very next day he would have died from an incurable disease anyway. So I shoot him in the head, a great big bullet in the head, instantly dead. But we know for sure that he would have died from an incurable disease the very next day. My case comes for trial 6 months later, and I'm charged with murder. So I'm charged with murder in this case. Can I resist the charge of murder by saying, well, he would have been dead anyway? Yeah? He would have died anyway, so I didn't kill him. Right? The answer to that is no. This is just like the melting ice case. We judge whether I've killed him at the moment of time when the bullet strikes, not the subsequent moment of time of time of trial. So we don't ask the question at time of trial, would he be alive or not? That's not the relevant question for law. For us as lawyers, the question of whether or not I killed him is judged at the moment at which my actions impacted upon him, not from the subsequent moment of trial. So what we're not asking is the question of whether or not my actions caused the state of affairs today of his being dead. That isn't the relevant question for the criminal law. I'll give you another example. I hate this example. So this example was thought up in the 30s by an American, and people have been trying to solve it for the last 80 years. So I'll just give you my version of this. This is the desert traveller case. Have people heard of the desert traveller case? No? Right, you'll love this. This is good. This is good stuff. Right? So the desert traveller case. What happens in the desert traveller case is this. We have a man who wants to cross the desert, and he has two enemies, two scumbags. Right? Scumbag number one wants to kill him. So what he does is he pours poison into the desert traveller's water bottles. And it's a poison which will instantly kill you if you drink a drop of it. That's what villain number one does. Villain number two, scumbag two, knows nothing of the actions of scumbag one, Scumbag 2 wants to kill me as well. So what Scumbag 2 does is he pours the contents of my water bottles away, believing them to be full of water. So he pours them away. Of course it's poison, but he thinks it's water. I set off across the desert, get halfway across, look at my water bottles, oh bugger, nothing in there, and drop dead of thirst a couple of hours later. Right? So then the question is, as a matter of law, which one of these swine caused me to die? Yeah? Was it Scumbag 1 and his poison, or was it Scumbag 2 and his pouring out of the water? Well, I'll give you the punchline. I think the answer is Scumbag 2, right? Not Scumbag 1. But that looks on its face to be difficult, because you might argue, well, Scumbag 2 didn't kill him, because what would have happened if Scumbag 2 hadn't poured away the water? Well, what would have happened would have been, I would have taken a sip from the bottle, I would have instantly died. So actually, what he did actually prolonged my life. Yeah, so his action in pouring away the water meant that I had a couple of hours extra. Yeah, so you might say, well, how could he have caused you to die then, if he actually caused you to have a longer life? Well, this, I think, ladies and gentlemen, is an example of preemption. So this is just like the example of the two shots at the rabbit, one of which hits the first, preventing the other one from hitting. What we have to ask is, what actions were actually sufficient for the set of conditions necessary for my death? What was actually sufficient? And that involves our asking the question of what actually caused me to die. Yeah, what actually caused me to die was thirst, the lack of water. So that Scumbag number 2's actions preempted the effect of Scumbag number 1's poisoning of the water. So the correct answer is that Nayers is the murderer, he goes down for murder, and Patel is only, in inverted commas, an attempted murderer. Yeah, so he didn't actually kill me. You might, one tiny little wrinkle on that's the answer. Right? One tiny little wrinkle is you might argue that once these two have done these things, that they're actually under a duty to warn me before I set off. As soon as they've actually done this, that they're actually under a duty to warn me that my bottles don't contain water. And if either of them had warned me before I started walking, I would never have died. So you could argue, I just give you the argument, you could argue that Patel's the murderer, but not through pouring the poison into the bottles, but because he failed to warn me of the contents of them before I set off. So I just give you the argument, right? It's just an argument. Okay, that's crime. Contract. Let me give you some contract law next. Contract law. Contract law is an interesting example of an area of law where we hold people responsible for events even though they've not caused them. So contract law is a classic example of an area where people are held responsible without having caused anything. So an example of that would be there's an Australian case where a salvage company agreed to salvage a ship which was on the high seas. Yeah? And they agree that absolutely, so they undertake the risk of the ship's non-existence. As it happens, the ship had already sunk at the time of the agreement, and so there wasn't a ship to be rescued. The contract was not void for mistake because they'd assumed the risk of the existence or non-existence of the ship, so they were liable for not having salvaged. So they were held liable in damages for not having salvaged the ship. But notice there was nothing they could have done. They did not cause, in any meaningful sense, the lack of the ship. There was nothing they could have done to salvage it. So contract is a classic example of how you can assume responsibility and be held responsible as a matter of law without having caused anything. Okay, more interesting example. This time, what happens is this. I am a builder. I'm a builder. And I need to get some supplies to do some work. And so what I do is I contract with a bricks supplier, you're the brick supplier, to supply me with bricks, and a mortar supplier to supply me with mortar. And my understanding of building work is in order to do building work, you need actually both bricks and mortar. I might be wrong. But that's my understanding. So one supply me with mortar, one's to supply me with bricks. Both are bad suppliers, and neither of them supply me with anything. So I've got a claim for breach of contract against the brick supplier and a claim for breach of contract against the mortar supplier, because neither of them have done what they agreed to do. As a result of my not having any bricks and mortar, I lose the really lucrative contract I've got for the building of a prestigious, business centre over there. It's an astonishing sum of money. So I've lost a huge sum of money as a result of the non-supply of bricks and mortar. So what I do is I sue the brick supplier, and I say, you in breach of contract failed to supply me with bricks, compensate me for the loss I've suffered as a result. To which our brick supplier says, hold on, no. My breach of contract caused you no loss at all. That if I'd supplied you with the bricks, you would still not have been able to do any work because you didn't have any mortar. So the brick supplier says, my breach of contract caused you no loss at all. Oh, that's a bit unfortunate. So what I do is I sue the mortar supplier. I say, right, you're the one then. Your breach of contract caused me to lose this lucrative contract, blah, blah, blah. To which he says, no. That's not true. You would have suffered the same loss anyway because you didn't have any bricks. So my breach of contract caused you no loss at all. Well, what's the answer? I think the answer is it's true to say that neither the non-supply of bricks nor the non-supply of mortar caused me, taken in isolation, this loss. They didn't. It's just like the 2 bullet holes in the head, just that this case concerns breach of contract. But what they both did was they both contributed. Each of them individually contributed to my loss. And the law treats that as sufficient to hold them each individually responsible. The fact that you, the brick supplier, are contributing to my loss in that example is sufficient for me to hold you liable for damages. So it's not the case that the brick supplier caused the loss, but they are responsible because they contributed. Okay? Contrast that example with this simple example. Instead of this scenario, what happens is I need bricks and mortar, I contract with the brick supplier to supply me with bricks, and then I'm an idiot. I just forget to order any mortar. Oh. So I've got no mortar because I forgot. Yeah, I forgot. Now this time I sue the brick supplier and I claim damages. This time I think she can resist the claim for damages for loss. This time she can say, I didn't cause the loss because you would have suffered it anyway. And this time it's not the case that this loss is the responsibility of one or more human agents other than me, because this loss is also my responsibility and I'm not a wrongdoer. In which case, where I only forget to order the mortar, I can't sue the brick supplier who doesn't supply me. Yeah? But her causal relation to this loss is identical in both cases. Her causal relation doesn't differ from one case to the next, but it's only in the case where they're both in breach where we both hold them responsible as a matter of law. That's contract law. Okay, tort law, very quickly. A couple of examples in tort law where we allow contribution to suffice. So if you go and read Clemens and Clemens in the Supreme Court of Canada, in Clemens and Clemens in the Supreme Court, they say some very loose things about contribution to injury not being an accurate term. That's not quite right. Sometimes the law does treat contribution as being enough, so that what they say in Clemens and Clemens is a bit loose, although they didn't have these cases in mind. So, an example. Say I misrepresent to Stephen that it would be a great investment to go and buy some shares in Nayers Limited, suppliers of, I don't know, bondage gear to the gentry. So I misrepresent this fact, and Stephen doesn't really trust me very much, but it forms part of his decision. So one of the reasons he buys these shares, one of the reasons, but not the sole reason or even a necessary reason, is what I said. So he makes the investment in these shares, and it's a disaster. It's an absolute disaster. Now let's assume that I'm guilty of deceit. So I've told lies to Stephen. Yeah? So I'm guilty of deceit because I've told him lies. If he sues me for damages, is it necessary for him to show that he would not have made the investment but for my misstatement? So is it necessary for him to show that my misrepresentation caused the loss? And the answer to that, according to orthodoxy, is no. All that you need to show is it was operating in his mind at the time. Put another way, all you need to show is that it contributed to the loss. Just as long as my lies contributed to the loss he suffers, that's enough according to the law. Causation isn't required. Why? Well, I think in this case, what's closing the gap is my high degree of fault. If I'm a scumbag who goes around telling people lies, deceives people, we're much happier as a matter of law to hold them responsible for outcomes even though they've not caused them. Okay. One other last example, then I'll shut up because I've gone on too long. Last example is public nuisance. And public nuisance, you don't require causation to be shown either. Contribution is enough. So say we have a river flowing through London, and if that river has 1,000 gallons of pollutant in it, it is considered to be a public nuisance. Below 1,000 it's not a public nuisance, over 1,000 is a public nuisance. And every single one of us in this room contribute a gallon. So we all pour a gallon in, one. But none of us pour anywhere near 1,000. The river now has 1,001 gallons of pollution in it. And you are sued for public nuisance. So this individual who contributed 1 gallon is sued for public nuisance. Well, we cannot say that he caused the public nuisance. Yeah? The public nuisance would have been there anyway. It may have way over 1,000. So just like the voters who cast the individual votes, we can't say against the person who put 1 gallon in that they caused the pollution. They didn't. It would have happened anyway. But what we can say is that they contributed. That everybody who put 1 gallon in contributed to the public nuisance of that river being polluted. And then the question for the law is it enough? Is it enough to say that you merely contributed to say, well, you're going to be held responsible? And the answer in relation to public nuisance is yes, it is. It is enough. But that is not always the case. It isn't the case that the law always says contribution is enough. In, for example, personal injuries law, we don't say contribution is enough. So if you go and read Clemens and Clemens, in Clemens and Clemens, the Supreme Court of Canada are quite clear. They set out a bright line rule for first instance judges who are presumably too thick to have anything set down for them which isn't spelled out in language of children, the Supreme Court seem to think. Well, they make it quite clear the test is a but-for test. You have to show but for my negligence, but for the defendant's negligence, the injury would not have happened. So that in relation to personal injuries, you're clearly applying a causal test. Yeah. The error is to think that we always apply causal tests. We don't. Sometimes in law we select a contribution test, and it's perfectly acceptable for the law to do that because what the law is really interested in is responsibility and not actually causation necessarily. And that's all I've got to say. Thank you very much for listening. That was quite tricky.